My name is Daniel Firdaus bin Nuril with matric number 255086, and I will be presenting the case of Juraimi Hussein against public prosecutor. This case involved the murder of Datuk Mazlan, the deceased, who is a state assemblyman for the state of Pahang. Datuk Mazlan was reported missing after withdrawing 300,000 ringgit from a bank. Police found the deceased's body in a house occupied by the accused, namely Juraimi, Mazna and Afendi. They were arrested and tried in Temulang High Court by a 7-person jury, and the court found all three of them guilty and sentenced them to death by hanging. On appeal, the complaints directed at the evidence circumstances adduced by the prosecution. There was no direct evidence, but the prosecution adduced some relevant facts, such as the decapitated body of the deceased that recovered from the house occupied by the three appellants, and the recovery of the murder weapons in this case, and the body of the deceased was buried in a house in the ground after he was killed. This means that the whole must have been done earlier, leading to the inference that there was a pre-arranged plan on the part of the appellants to kill the deceased. The court rejected the arguments and the appeals were dismissed. The verdict of the jury was affirmed. The sentence of death passed upon each accused was upheld. This is a brutal case and done by the cruel individuals. I agree with the decision of the Court of Appeal in dismissing the appellant's appeal. After analysing the relevant facts adduced by the prosecution, the court satisfied that the prosecution has proved the case beyond a reasonable doubt, and the failure of the appellants to defend and provide justification in rebutting the relevant facts produced by the prosecution. Therefore, this means that the strength of the evidence will somehow rely on the facts of the case and the ability of the evidence to stand by itself. It should be noted that the nature of circumstances is weak. Circumstantial evidence is unable to stand alone without the support of other circumstantial evidence. However, it may be possible to secure convictions. This case illustrates how circumstantial evidence can be strong enough to secure a guilty charge. The prosecution successfully links the circumstantial evidence to secure the convictions against the three appellants.
Section 5 of the Evidence Act 1950 provides that if the evidence is relevant, then it is admissible.
On the other hand, Section 3 of the Evidence Act provides that a fact is said to be relevant when it is connected with another so as to make the other more or less probable. Therefore, as long as the evidence is related to the facts and circumstances of the case, the circumstantial evidence can be admitted. The judge stated that the conduct of the accused following to the disappearance of Datuk Mazlan and their failure to provide the reliable explanation to the several incriminating circumstances against them, leaving no room for any reasonable doubt as to their guilt. In the case of Sunny Eng against public prosecutor, the appellant was charged with murdering his girlfriend, although the dead body was never found. The facts presented by the prosecution was so convincing that the court reached an irresistible conclusion that the appellant killed the deceased. Furthermore, in the case of public prosecutor against Sarjit Kaur, the prosecution only relied on circumstantial evidence to try to prove that the defendant murdered her husband. To sum up, the two cases above illustrates that even if there is no direct evidence, the circumstantial evidence may be reasonable enough to establish a prima facie case and bring justice to the deceased. In conclusion, in order to rely on the circumstantial evidence, the prosecution has the responsibility to ensure that the evidence is strong enough and does not raise doubts that may cause the prosecution fails to establish a prima facie case. In the process of collecting evidence, if a rock is lost, the court will consider whether the rock will have a secondary or significant impact on the evidence to be relevant in the court. My suggestion that can be done to improve the evidentiary aspect of circumstantial evidence in the courts is the legislative can legislate a specific provision on the procedures and the conditions for accepting relevant facts as evidence in court. Furthermore, the court must be cautious and fair in analysing all the evidence and be satisfied that the case has proved beyond the reasonable doubt. And that's all for me. Thank you.